Justin, first and foremost, we have a legal clash over mining rights making its way to the Western Cape High Court. What exactly is the issue at hand here?
That's correct. It's essentially there's a dispute about which legal permits and authorizations are required before a mining operator can commence mining.
Well, if we look at the laws that are currently at play, I mean, there are various laws. Why the overlap in the first place, where surely these laws on a local, on a provincial and a national level should be synchronized to work more effectively in the spirit of cooperative governance?
Yeah. Look, our case, as legal representatives for the Minister of the Provincial Minister of Environmental Affairs, is that the systems are there for there to be an efficient integration of these decision-making processes. Obviously you have three spheres, each with its own legislation. The Mining Act, the Minerals and Petroleum Resources Development Act, makes provision for the consideration of mining, whereas the National Environmental Management Act is specific an environmental permitting act. The Land Use Planning Ordinance, on the other hand, is specific to local authority and empowers them to determine their town planning structures, their zonings, etc. So our argument is that none of these bits of legislation is mutually exclusive of the others, regardless whether mining, as they say, is an exclusive national competence. There are other laws that apply, each with their own specific area of focus, and that needs to be complied with.
Well, the mining law itself is the Minerals and Petroleum Resources Development Act, and it's the law which mining company Maxsand in this instant holds. It infers rights that are not necessarily possible at this stage. Are we looking at a possible revision of this act where it currently trumps, as you say, all other legislation?
Yeah, look, it's the Minerals Department's view that it trumps all other legislation. We disagree with that view. We believe that they can be read together and can be integrated, and that there isn't any merit in the department's claim that it will cause administrative chaos and so on. If you look at the National Environmental Management Act, it has specific provisions in there for the manner in which decisions should be integrated between the various regulators. Sorry, to come back to your question, the Minerals and Petroleum Resources Development Act at this stage there's no contemplation that it's going to be amended. What is contemplated is that mining activities will be incorporated under the National Environmental Management Act as listed activities. However, that hasn't come into effect yet. It's in draft form, and it hasn't come into effect yet, and only once it comes into effect will specific mining activities be incorporated as listed activities under the National Environmental Management Act, and therefore require consideration under the National Environmental Management Act specifically. But one of the issues in dispute here is also activities related to mining. So, for instance, regardless of those specific mining activities, you have a number of other activities linked to mining operations, whether it's the construction of roads of a certain size, the laying of underground pipelines, etc.
Well, the challenge at this stage is for government then to get the systems in place effectively. It still doesn't sound like there's any easy resolution that's going to come to the fore. What time frame are you looking at for common ground to be reached?
Look, there are. This is not a dispute which has arisen overnight. I mean, it's a dispute which has been ongoing between the Western Cape Provincial Department of Environmental Affairs, supported by the National Department of Environmental Affairs, and the Department of Minerals and Energy for approximately 10 years now. So it's not as though there haven't been attempts to resolve the dispute. Regrettably, the National Department of Minerals and Energy, as it was previously, has not entertained, we say in the spirit of cooperative governance, the Western Cape Department and the National Department's views on the interpretation of mining with environmental activities. and has gone so far as to instruct mining rights holders that they don't have to comply with the Western Cape Provincial Department's request that they also apply in terms of NEMA. So there's unfortunately been a breakdown of cooperative governance, which has essentially led us to the point where we are now, where we're asking the courts to provide the relief that we seek.
Well, should the city and the province be correct in their interpretations, what do you see being the implications for mining companies themselves moving forward?
Look, the implications initially are obviously going to be that the regulators need to scramble around and get their systems in place to make sure that all the relevant permits and permitting processes are integrated and that they dovetail, so that you don't have administrative delays and bottlenecks when it comes to approving mining operations, the consideration and approval of mining operations. So I think the immediate challenge, and it's probably a challenge which has already been addressed to an extent, in the amendments to NEMA. But the immediate challenge is to make sure that, or for the regulatory bodies at national, provincial, and local government level, to make sure that they get their systems in place to process these applications timeously.
Well, Justin, good luck, and we're going to leave it there. Thanks so much for your time this afternoon.